that if corporations are allowed to flood the campaign with money, it will be unfair to individuals because corporations have the resources to dominate the election and individuals don't have anywhere near the resources to compete. And what the law ought to do, the reasoning was back in 1990, what the law ought to do is equalize voices, level the playing field by restricting corporations from making independent expenditures. They're already prohibited from contributing directly to a candidate, but prohibit them from acting independently to drown out all the people like you who would like to have your voice heard. Justice Kennedy, as you see in the summary in the reader, Justice Kennedy considered that rationale and rejected it for the court. Lots of problems that can be invented with that rationale. And if what moves you is that there ought to be more speech, not less, and that the identity of the speaker is not what counts, it's the content of the political speech, then any restriction on that speech ought to be suspect. And what the court did was apply strict scrutiny. Since the restriction in this case was content-based, that is, the law was triggered by the content of speech, what the corporation was wanting to say, but strict scrutiny was required. This we will encounter time and again throughout this course. This principle that when government enacts a law that is content-based, targeting particular content that it wants to suppress, that triggers the requirement that the court exercise strict scrutiny. Not relaxed, not we'll give them a pass, not we'll give them a lot of deference, but we are going to strictly scrutinize the justification that government offers for this law. And that requires the court to consider two things: whether the government can show that it has a compelling interest in suppressing this kind of speech. Compelling, not important, not substantial, not significant, compelling. A really strong interest in suppressing this kind of speech. And second, that the particular restriction is narrowly tailored to serve the particular restriction. That means that the law can't be over-inclusive, prohibiting all kinds of things besides what the government can legitimately say serves the compelling interest, and it can't be under-inclusive, that is, not outlawing a lot of things that seemingly would serve the compelling interest. Well, as I read the Citizens United decision, I've reread it again a couple of days. I spared you the decision because it's 176 pages long, and it's very dense. As I read the decision, Justice Kennedy for the court decided that none of the three rationales, I'll come to the other two, the first one being the anti-distortion rationale, don't let corporations distort the electoral process by flooding it with money. Justice Kennedy for the court decided that that was not, in fact, a compelling government interest for the reasons that he expresses that are a little hard for me to communicate, but that are hinted at in the summary in the reader. And he didn't carefully distinguish, the opinion didn't carefully distinguish between is there a compelling interest and is it narrowly tailored, because he found that the argument, the rationale that this would distort the electoral process was not all that important. I guess you'd say it is important if you show that it actually distorts elections, but he found fault with the law and its tailoring. That is, was it narrowly tailored to serve the anti-distortion rationale? And he points out how it was overbroad and under-inclusive as well. Under-inclusive, for example, in one respect. The law excluded media corporations. Well, media corporations may have $1 zillion. Many of them do. Look at News Corp. Rupert Murdoch's company. It's a media corporation, right? It's got $1 zillion, and it's exempt from the law. Well, how can the government justify doing that? Can it really have a compelling interest in eliminating all corporate contributions, all corporate issue ads, candidate attacking ads, at the same time that allows News Corporation to do whatever it wants to do? The other two rationales that the court had adopted in the Austin case in 1990, the corruption rationale, the fear that allowing corporations to contribute, to take out ads supporting or opposing candidates will corrupt the politicians, or at least create the appearance of corruption. The corporations spend a fortune relieving the candidate from the necessity of doing so, supporting a candidate, or attacking the candidate's opponent. That's great stuff for a politician, when you can get somebody else's money to do the job for you. And that leads, the court said back in 1990, to at least the appearance of corruption, if not actual corruption. That is, that the politician, once elected, will return the favor, will give the funding corporate sponsor something that they want, a payback, a quid pro quo. Well, Justice Kennedy's opinion in Citizens United recognized that that was, in general, a valid interest of the government, preventing corruption and even the appearance of corruption. But in the exercise of strict scrutiny, looked so carefully at the government's rationale that it just tore it apart, saying basically that in order for the government to succeed, it had to be able to show quid pro quo corruption, swapping political favors for the corporate support. And if you couldn't show that, government, you can't justify relying on the anti-corruption rationale. You can't simply say, in general, this would create the suspicion among voters and people that corporations are really running the show here. That's not sufficient. It has to be fairly specific, showing that corporate money has contaminated particular politicians. And the government didn't do it in the Citizens United case. As Justice Stevens pointed out in his dissent, his 90-page dissent, he was almost 90 years old at the time he wrote it. When he retired, now almost 2 years ago, he was 90. But he wrote this masterful dissent. And one of the small points he made is the government didn't put into the record whatever corruption evidence it might be able to present, because it didn't know that the court was going to consider the law on its face in all of its applications, rather than simply as applied to Citizens United. There wasn't any evidence of corruption regarding Citizens United's negative ad about Hillary Clinton. So the majority was able to say, well, we don't have anything here. But the reason they didn't have anything is because the government didn't know until the Supreme Court changed the case, opened it up to an on-its-face attack, that it had to have a record of corruption of any kind. Robert? Yeah, I mean, yeah, sure, what? But isn't it a little bit of a sledgehammer or a little crude instrument it's a prophylactic that will prevent, yes, it is, that would prevent corporate spending from contaminating a particular politician. Yeah, it would, but at what cost? I mean, that means corporations can't speak at all in electoral campaigns. That's a crude instrument to solve a specific problem. Justice Stevens says in his dissent that what the court should have been alert to is the risk of undue influence by corporations on the electoral process. Don't limit it so narrowly to quid pro quo corruption. Look at whether corporate funding of elections creates an undue influence, or at least the appearance of undue influence, corporations dominating the political process. The court, of course, rejected that. The third rationale that the government relied on was the shareholder protection rationale, the idea being that there will probably be some shareholders of corporations who disagree with the political stance taken by the corporation, spending the corporate money, spending the shareholders' money on ads favoring a candidate whom the individual shareholder detests. You're using my money to support a candidate that I don't want anything to do with. And there's something to that, but it can't carry the freight of outlawing, Justice Kennedy said, of this blunderbuss law that outlaws any spending by corporations, including sole shareholder corporations, where the only shareholder is the one who's making the decision. And it just doesn't make any sense there. The law is overbroad in that respect. The problem can be solved, according to Justice Kennedy, by greater use of corporate democracy, allowing shareholders to present propositions to their to the bosses of the corporation, the directors, and so on, saying, don't do that, don't take political positions at all, or certainly don't support candidate X over my objection. The reliance on corporate governance is a little bit fanciful. I don't know how much you know about how corporations operate, but minority stockholders virtually never win. So it's a little bit illusory to say that we're going to rely on corporate governance. So Justice Kennedy rejects all three of the rationales offered up by the government for supporting this law. Justice Stevens wrote this eloquent, beautifully reasoned, careful 90-page dissent in the case. And he's complained about the way the court set up the case procedurally, taking it away from what the parties had contended and deciding what the five justices wanted to decide. He said that they had manufactured a facial attack on campaign finance laws. Essentially, five justices were unhappy with the limited nature of the case before us, so they changed the case to give themselves an opportunity to change the law. And he said that this path to decision is likely to cause damage to the court. It was, to me, reminiscent of the dissenting opinion he wrote in the 2000 case of Bush versus Gore, which you remember is the 5-4 decision of the Supreme Court that delivered the election to George Bush. In another rush of judicial activism, the court interfered with the counting of votes in Florida, stopped the counting of votes in Florida when it looked like Al Gore might win, and basically installed George W. Bush in office as the President of the United States. It was another breathtaking example of judicial activism, and Justice Stevens sees the Citizens United case in much the same way. Justice Roberts was apparently stung by that criticism and undertook to write a whole separate concurring opinion defending the majority of the court against this accusation of judicial activism. He said it's not enough that a decision be narrow. That's not a value that has to be adopted in every case. It must not just be narrow, the decision must be right. And it was the right thing to do to strike down this law. On the question of stare decisis, he said that's not an absolute rule. And of course, everybody agrees, Justice Stevens included, everybody agrees that stare decisis is not an absolute rule. Roberts points out that if it were, we would still have racially segregated schools. Plessy versus Ferguson in the 1890s says separate but equal is okay. Brown versus Board of Education in 1954 overruled Plessy versus Ferguson. Give the back of his hand to the doctrine of stare decisis. And once again, it's more important to be right than it is to be consistent. The decision can be viewed, I think, by a cynic as a faux First Amendment decision, a faux free speech decision, that is, that it's really a pro-business decision dressed up in First Amendment clothes. The five members of the conservative majority on the court all came to Washington as part of the Reagan Revolution in the 1980s, one of whose main tenets, main beliefs, is get government off the backs of business. Get rid of unnecessary regulation of business. And the regulations of campaign finance had to rankle these people because they're so intrusive, they're so detailed, they're so difficult for ordinary people to figure out. If I go to the Federal Election Commission website and try to figure out what in the world one has to do in order to comply with this law, it's very difficult for anybody to do. And I think the majority of the court was animated as much by their anti-regulation ideology. They're pro-business. Let business be free. Free enterprise is what drives this country and makes it prosperous and so on. They're animated as much by that ideology as they were by antipathy to restrictions on political speech. Justice Kennedy said that the court, this deals with the question of whether corporations ought to have free speech rights at all. How many of you think that they should have? And how many of you think they shouldn't have? A few more. Most of you don't give a damn. Just abstain on the issue. I don't care whether corporations have free speech rights. Or, yeah?
I mean, I understand the distinction between protecting speech and speaker, but I mean, aren't the implications kind of ridiculous? Like, when are corporations going to have the right to vote? When are they going to get? When are they going to be able to plead the fifth? I mean, I just think it's kind of, I think the implications are ridiculous.
Mm-hmm. Corporations are not individual human beings for all purposes. But what do you do with media corporations, for example? Say that they don't have the right to, the New York Times, CBS, they don't have any free speech rights, and the implication of that is that they can be censored at will by government. They don't have any First Amendment rights. They can be put out of business. They can be censored. They can be told only news that favors the Republican agenda can be broadcast and so on. What do you do with that?
Well, I think that's a pragmatic balance between interests. I think that I think the anti-distortion thing is really strong. I think that when you're protecting their speech, you're also limiting other speech. So I think that just has to balance. I think that yeah, I think that's there's good argument on both sides, but I think that I really think that the anti-distortion thing is really important. I think so.
And did you answer my question about what do you do with media corporations?
Yeah, I think you have to limit it.
Limit the media corporation. Limit it meaning they don't have a First Amendment right to speak.
No, I think you have to limit their First Amendment right to speak, not limit it. I understand.
It may be possible, you may be onto something here, it may be possible to limit even media corporations' right to speak in an election, because that's all you're concerned about here, without eliminating their ability to cover the news whenever they want. The problem is, we depend on media corporations to tell us what's going on in the election campaigns and so on. And to say to them, they can't take a position, favoring or disfavoring a candidate, is a pretty radical departure from what we've lived with, yeah. Well, the editorial page of the New York Times routinely in every election endorses somebody or opposes somebody. It's the New York Times. It's not signed by anybody.
I mean, a lot of people are still reading it regardless.
No?
I'm not the restriction on media corporations in that it's published in the New York Times, people leave out New York Times for their opinion, they can read the New York Times. But like General Electric, you can go to NBC to give your opinion, but they can't like tell you like, oh, you'll buy this your vote for McDonald's.
They can't.
Well, they shouldn't.
Would that distort the electoral process if there was a little tag attached to the light bulb that said vote for Mitt Romney?
You're not buying the light bulb like you buy the newspaper. You're not buying light bulb because you want an opinion. You're buying light bulb because you want to read the newspaper. Like, you buy newspaper for the opinion.
Well, in the decision, Justice Kennedy cited 24 decisions of the court, starting in the middle of the 20th century, that decided free speech claims involving corporations, allowing corporations to speak. One of them, for example, is the Pentagon Papers case, which we'll consider very soon in this course, where the government attempted to stop the New York Times from publishing the Pentagon Papers, the expose of how the United States got involved in Vietnam. If the New York Times did not have First Amendment rights, it would have lost that case. Another case is the extremely important case, New York Times, again, versus Sullivan, the libel case back in the 1960s, which we'll consider in a couple of weeks, that in effect gave us all, in a case decided in favor of a corporation, the New York Times Company, gave us all the right to criticize government, even falsely in some circumstances. These are opinions of monumental importance to our First Amendment rights, the rights of all of us, that happen to have been decided in cases where corporations were the speakers. You want to wipe all those out by saying corporations don't have a right to speak, Jen?